This is case number 21, 153543. This is Integrated MRI Center LLC versus City of Detroit. Your appearance for the plaintiff in this matter.
Howard Cohen appearing on behalf of the plaintiff, Your Honor, P41346.
Thank you, counsel. Good morning to you.
Morning.
For the City of Detroit at this time, your appearance, please.
Good morning, Your Honor. Charlotte Bennett here on behalf of defendant City of Detroit, P85699.
All right, good morning to you as well, counsel. It looks like I have this matter set on for review. I do see it looked like there was a recent, somebody update me on what's going on, how far along you are at this time.
Sure, Your Honor. So this is you're correct. Your return hearing on defendant's motion for summary disposition and motion for declaratory relief in lieu of answer. And you did grant our partial motion for summary disposition at our last hearing, but you held your ruling on the declaratory relief in abeyance until today. And the issue before the court as far as the declaratory relief goes is that plaintiff's complaint specifically identifies that there's $5,200 in outstanding damages to be had in this claim, which stems from a single date of service. I believe their most recent date of service, November 5th of 2020. And they are, I believe in response to our motion, and of course plaintiff's counsel can speak to this, requesting that the court deny our declaratory relief and instead allow them to amend their complaint to add 3 additional dates of service from 2019. So we are here on those issues, Your Honor, and I'm happy to go into my argument now if you'd like.
All right, in as much as counsel has swore that the plaintiff has indicated in this matter that they wish to amend the complaint, let me hear from counsel for plaintiff at this time.
Yes, Your Honor. In the complaint, while it indicated in the body of the complaint that we were seeking $5,200, the exhibit attached to the complaint actually had all of the 4 bills or dates of service for $22,300 attached to it. So it was simply an oversight and a mistake on our part. And we asked that we be allowed to amend the complaint because the actual documentation was attached. It was just a mistake made in the complaint, which shouldn't come as any shock because the bills had been submitted previously, not paid, and then the lawsuit had been filed with the bills attached.
Right, Madam Counsel.
Yes, Your Honor. So the main crux of our issue here as far as the amendment goes and the declaratory relief from our perspective is the 1-year back rule, Your Honor, as the dates of service that they wish to add. They were previously plaintiff filed a different lawsuit also in 36th District that was assigned to Judge Robinson handling those 3 dates of service. Then they filed this lawsuit handling the single date of service, the $5,200 date of service at issue in this lawsuit presently. After both lawsuits were filed, Judge Robinson did dismiss without prejudice the first lawsuit, the one for the 3 2019 dates of service. And it was only after that occurred that plaintiff is now requesting that all of those dates of service be heard in this lawsuit. And as Your Honor is aware, there's no tolling of the 1-year back rule unless by stipulation of the parties. And there was no stipulation to that, certainly to my knowledge. And since it wasn't a stipulated order of dismissal, I don't think that would have been included in the order of dismissal. So the 1-year back rule still stands in this situation. And therefore, those 2019 dates of service aren't going to be able to be prosecuted in this lawsuit that was not filed until April of 2021, it looks like.
All right, counsel.
You got me there.
argument is, first of all, in the first instance, it would be the court's inclination to allow the amendment, because amendments are to be freely allowed where justice so requires. There's a secondary question that has arisen, and that question is whether or not those claims could survive to the extent that the court allows those claims to be admitted by way of a motion to amend. So I think that you may be on all fours as it relates to the motion to amend, but it seems that counsel has orally moved that the court would either not allow the amendment or upon allowing the amendment would allow those matters to be dismissed under the 1-year back rule. So, Mr. Coleman, anything?
No, I think with that understanding of the timing of the filing of the complaint and the 1-year back rule, I think only the last date of service survives. I don't know if you want to do it by amendment or you just want to rule that that's the one date of service in that complaint that was filed.
All right. In as much as it seems that the parties here are on the same page, and I won't foreclose the possibility of addressing this issue in the future, given the 1-year back rule seeming to have some application to when notification is given, but there being no argument on the floor in that regard at this time, I will deny the request to amend the complaint specifically because of there does not seem to be a defense to the 1-year back rule. Otherwise, if justice will require the amendment of the complaint, it would seem to be an unwise act in this regard, to the extent that those claims would not be allowable under the no fault rule. So for that reason, I will not allow the amendment. That's almost going to ruling on the secondary issue, but I'm not allowing the amendment because it seems that the secondary issue would make the amendment a kind of issue. So the motion for the declaratory relief is granted in this matter, and the motion to amend is denied at this time. So
Thank you, Your Honor. Should I draft a order to that effect?
yeah, that's exactly right. And if you would, you have the email address where you can submit that right away.
If you'll give it to me, that would be great. I might have it, but I want to make sure.
Let's make sure. That's Latifah, LATIFAH .Hunter@36districtcourt.org.
Okay. Thank you, Your Honor.
Thank you.
All right. Good day to the two of you.
You too.
You as well.
The court now calls case number 21-153657. This is Economics Private Student Loan Trust versus Clarence Steele. Matter is before the court. Looks like I don't have a complete file, but it's on an application for bit of garnishment or objections to the same. So, all right, let's get the appearances on the record for the plaintiff regarding this matter, please.
Thank you, Your Honor. Jennifer Dillow, P69855, appearing on behalf of the plaintiff.
All right, thank you, Ms. Dillow. Good morning to you. I'm looking now for Mr. Clarence Steele or someone representing Mr. Steele. Go right ahead at this time.
Clarence Steele here, Your Honor. Good morning.
Good morning to you, Mr. Steele. All right, so it looks like a judgment was entered in this matter on the 30th of September 2021. That judgment is $18,900. Strike that $18,890.25. I see subsequent actions thereafter for motion for installment payments. I also see something that relates to the income tax garnishment. Madam Counsel, I look like I have a note on this to review the payment or something along those lines. Update me on what's going on, please.
Yes, Your Honor. When we were here in December 15th, the court entered an installment payment order requiring the defendant to make payments of $100 per month, starting January 14th, 2022. It was to be reviewed in 6 months, which is the point of today's hearing, for the court to review the defendant's installment payments to see if we can increase the amount of payment.
Yeah, and the specific reason for that is because of the amount of the judgment, and the payment would not cover too much, given that it's only $100 and the judgment is in excess of $18,000. So, Mr. Beal, tell me about that. It looks like the payment on this should be increased to try to cover some of a higher portion of what the embedded is. Talk to me, sir.
Yes, Your Honor. I'm still somewhat facing financial hardship. I have made every payment on time with $100 a month. If we were to increase it, I would like to try and ask maybe just a small amount, like 120 to 150, Your Honor.
All right. So are you working the same job, or have you transitioned to something different, or what?
No, I'm working the same job, Your Honor. I have increased my hours a little bit, but I've been interviewing, looking for better work.
All right. So I know you got a lot of obligations, but roughly, what are you being able to bring home? What do you pay bi-weekly?
Bi-weekly is like 220 to 250, Your Honor.
$220 you say you're bringing home?
Yes, sir.
So what do you have? A lot of stuff being taken out? Is that what it is?
Well, it's just not a lot of stuff. It's just limited hours at the moment. I am paying a lot, but yeah.
All right, gotcha. All right, Madam Counsel, anything?
Yes, I would just point out the last payment we received was on April 25th, 2022. So we have not yet received the May payment that was due on May 14th, 2022. Maybe it's in transit, but as of today's date, we have not received it. The current balance is $18,604.22. Interest is accruing at 2.04%. Plaintiff is asking the court to increase the installment payments. Plaintiff would prefer the payment to get $200 per month right now. But $200 per month would take about 7.75 years to pay off the judgment, which is still rather lengthy. The $100 per month is going to take over 15 years, not including the interest.
All right. Under the circumstance, I will increase the payment to $150 per month, having listened to all the circumstances involved here. And that payment will commence with the month of June. $150 per month, beginning in the month of June. I will review this matter in January 2023. So we're going to get you a date so we can put a control on this for January of 2023. And that date's going to be in just one moment.
That's 9th of January.
That's going to be 1/9/23, and that's going to be at 9:30 a.m. You will get a notice in the mail regarding that date. It's a review date regarding the partial payment. I may not increase it at that time, but obviously the ideal here is to try and move this forward a bit, given the fact that it's such a huge amount. You want to get down below 18,000 sometime soon. Let's see if we can get some work. All right, so I'll review it at that time. Again, the order of the court increases the installment payment from 100 to 150, beginning in the month of June, on the date that it is normally due. So ordered this time.
Thank you.
All right, good day to you. All right, the court.
I'm here, Your
All right, good day. Case number 177-892. This is Dr. Athena, last name B, versus State Farm Mutual Automobile Insurance Company. The matter is before the court, set on for a looks like a first hearing on today's date. Your appearance for the plaintiff in this matter, please. Do I have someone for Michigan Paying Specialist versus State Farm? Anybody on either side of that? All right, I'll recall that matter shortly after response in that regard. The court now calls case number 2164776. This is for your recovery therapy versus Michigan Auto Insurance Replacement Facility. Today is date and time set for a hearing on a motion. I previously granted an order to show cause in this matter. It looks like there is a there may be another motion pending as well. Your appearance for the plaintiff regarding this matter, please.
Eric Noga, P 83611, appearing on behalf of plaintiff.
All right, thank you, counsel, and good morning. Good to see you back again. For the defendant in this matter, your appearance at this time, counsel.
Good morning, Your Honor. It's Lisa Mahone, P 79890, on behalf of defendant.
All right, thank you, Ms. Mahone. I know that the court issued an order to show cause. I think I signed off on a bench warrant regarding this matter. It's something about defendant not, or strike that the claimant, the underlying claimant not showing up for a deposition or participating in a deposition. Update me on the status of things this time, Madam Counsel.
Yes, Your Honor. That is correct. We had a bench warrant in this matter for the underlying claimant. We did file a MSD in this matter based on non-cooperation by the claimant. However, it was brought to my attention this morning, actually, that plaintiff's counsel did not receive our MSD. I tried to look back through emails for my assistant, and I can't confirm that it was actually sent. So it was filed with the court and provided to the court, but I can't confirm that it was actually sent to plaintiff's attorney.
All right. And counsel, I believe, I think that's what you're getting ready to tell me, that you didn't receive the same, correct, sir?
That's correct. First time I received it was this morning per my request to Ms. Mahone.
I'm just looking through here. I've got a lot of stuff to file, and the motion did not jump out at me as the first thing here. Just one moment. Okay, and I do in fact have the motion. All right, so it looks like we need to set this over for a new date. So I will set it over, let me put it maybe 30 days out, and then we come back and the court will, that'll give you a chance, counsel, to respond to the motion and the court will conduct the jury.
That would be excellent, Your Honor. Thank you. Do you have a date?
Oh, you said 30 days out?
Yeah, I'm waiting on the clerk. She's gonna get it to me.
June the 22nd.
The 22nd of June, June 22nd, be the next action date regarding this matter. That's gonna be at 10 o'clock a.m.
That should work, Your Honor.
All right, good day to the two of you. And see you real
Thank you.
soon.
Thank you, too.
Thank you, Your Honor.
Yeah, I get it.
I need to keep this over here, so
Okay.
We're on the record in case number 21-171682. This is Midland Credit Management versus Derek Johnson. The matter is before the court, set on for first hearing status conference. I have received defendant's answer regarding this matter. Your appearance for the plaintiff, please.
Good morning, Your Honor. Gary Feynman appearing on behalf of Midland Credit Management, P41655.
Thank you, Mr. Feynman. Good morning to you, sir. I'm looking now for Derek Johnson. Derek Johnson, if you're on the Zoom, please say something at this time. The court notes that there is a notice that went out to Mr. Johnson regarding this matter. That notice went out on the 22nd of March with the correct Zoom number indicating that the defendant must appear for this hearing. Once again, I'm looking for Derek Johnson living on Kentfield. Hearing was set for 9:45 a.m. and is now 10:18 a.m. Looking at defendant's answer in this matter, he simply checks one box. it says, I disagree with the statement in paragraph 1 because I did not open said account or know of such account. And I can't make out the rest of what is written here. So it's not really a complete answer to the complaint in this matter, but there is simply a statement of disagreement. But the defendant is given the opportunity to appear on today's date. Counsel, your pleasure at this time, given that the defendant has not appeared, sir.
Your Honor, I would request entry of a default judgment in the amount, damages in the amount of $642.87. Filing fees of $55, motion fees of $20, service fees of $56.84 for a total judgment amount of $774.71.
All right, the court will enter the default of the defendant at this time based on the defendant's failure to appear, and the court will sign a judgment upon submission consistent with the terms as set forth on this record. So, counsel, you can email a copy of that of your proposed judgment, and we'll sign it and get it right back to you. You need the email address, sir?
No, I was listening earlier and I wrote it down, so.
All right, very well. All right.
Got it.
We awaiting your order, so as you submit that, I'll sign it and get it back to you, sir. All right, good day to you.
Thank you, Your Honor. You as well.
The court now calls case number 21-240-431. This is Marty Howard versus Michigan Auto Recovery. The matter is before the court on looks like a motion hearing on a motion for summary disposition. I think this is the second time up or something. Somebody had not received the motion. Your appearance for the plaintiff at this time, please.
Good morning, Your Honor. This is Thomas Stidham, P56504, appearing on behalf of the defendant, Michigan Auto Recovery Service, Inc. And with me on the line is Mr. Gregory Arrigo, Your Honor.
All right, thank you. I'm looking for Marty Howard, defendant, strike that plaintiff Howard in this matter. The record should reflect that the court set the motion on the hearing and sent it over for 9:45 on today's date, that there was a notice sent out to all parties to defendant, strike that to plaintiff Howard at the Longfellow address 904 Longfellow in the city of Detroit, setting forth this date as a date of hearing at 9:45 a.m. That notice went out on April 26, 2022. The correct Zoom address is noted on the document. Counsel, have you spoken with Mr. or have you spoken with the last name Howard regarding this matter since the motion's been pending, sir?
No, Your Honor. After the last at the last hearing, the court, if the court recalls, it reset the date and it asked me if there was, I told the court that I could supplement with an affidavit, which I did. I did serve it on Mr. Howard at that same address that the court just referenced. So, but I have not had, to answer the court's question directly, no, I've not had any contact with Mr. Howard other than serving that affidavit on him since our last court hearing, Your Honor.
Right, and my specific order was that the defendant must turn over video surveillance to plaintiff within 14 days or submit an affidavit of non-existence. That's what you're making reference to. Is that correct, sir?
That's correct, Your Honor.
And you're indicating to this court that you're in compliance with the order that the court issued. Is that correct, sir?
Yes, Judge. We submitted the affidavit on May 10th at, it looks like 8:21 a.m. is my timestamp copy.
All right, given that the plaintiff has not appeared in this matter, the court clearly gave notice of the next action date. Plaintiff has not appeared, and based on the non-appearance at this time, the court will dismiss this matter. That dismissal is without prejudice, where the defendant has not appeared. I'm sorry, the plaintiff has not appeared. Matter is dismissed at this time.
Thank you, Your Honor. Does the defendant need to submit an order, Judge, or?
Yeah, we'll send an order out to you, sir.
Okay, very well. Thank you, Your Honor. Have a good day.
Likewise.
Mr. Rego, you can log off now.
The court now calls case number 22-178940. This is First Medical Group versus City of Detroit. Matters before the court, settled for review on today's date. Excuse me. Your appearance for First Medical, please. For City of Detroit.
Good morning, Your Honor. Chelsea Grimaldi for the City of Detroit, P85585. And plaintiff's
Right.
counsel is actually on here, but he hopped off. It was Eric Noga.
Yeah, I saw him earlier.
Right.
And good morning to you. Have the two of you spoken at all?
Yeah, so we were actually able to resolve the case yesterday, and we will be filing a stipulation in order for voluntary dismissal for your review here shortly.
All right, very well. Now, is this a matter that has to go for city council approval or anything?
Nope, it won't need to go to city council.
All right, so you got the information to submit your order, is that correct, council?
Yes.
All right, all right. I wish you well. I'm noting on the file that the matter has been resolved and that I will anticipate an order of dismissal of this matter. Good day to you.
All right, thank you so much. Have a great day.
Sure.
That's what he is missing.
Oh, yeah. Mr. Flory, you got something with me, sir?
Good morning, Your Honor. Yes, I believe we have a hearing set today for Michigan pain specialists and biomolecular. It's case number ending.
I called that earlier. Yeah, go back on the record. The suffix is 7892. That's Michigan Pain Specialists and Biomolecular Integration versus State Farm Auto Insurance. Today is the date and time set for a hearing. Council, go ahead. Your appearance, I did not see anybody else. I did call this earlier. Your appearance at this time, sir.
Oh, I'm sorry, Your Honor. I had some technical issues with my laptop. I had to log in on my phone. Connor Clardy, P84485, appearing on behalf of the plaintiffs.
Thank you, counsel, and good morning to you. I haven't seen the other
Morning.
side of this, kind of what's going on here.
Well, I believe that I substituted in for Miss Cooley, who is on maternity leave on this case. I have not yet had an opportunity to speak with brother or sister counsel for State Farm. They may not be aware that there is a hearing set for today. I can call them quickly if you'd like, Your Honor, or if the court is inclined, we can adjourn it, but I can also call them real quick.
Yeah, I guess it looks like they just got their answer in, well, back in February. And I have not set up a scheduling order on this yet. Maybe I'll just set a scheduling order and we'll make sure that everybody gets a copy of that. And that's
Okay.
All right, so I will I will open the discovery in this matter, allow for discovery over the next 60 days, and then I'll set up a return date thereafter. And so the discovery cutoff and the next pretrial conference date is going to be
July 19th.
That's going to be July 19th. Just one moment. Make sure that works. Yeah. No, that's good. July. Yeah, July 19th. Okay. Yeah, July 19th, 2022, and that's going to be at 9:45 a.m. You'll get an order for that information contained in the order. And that order also, as you know, will allow for the filing of motions and setting motions for hearing on that date. And all of that will be contained in the order. So thank you.
Sounds good, Your Honor. I will also contact defense counsel's office and let them know of the next hearing date.
Thank you, sir. All right.
Thank you, Your Honor. Have a good day, Your Honor. Thank you.